Hi, I'm Steve Dans, and we're here today to talk about one critical element in almost all of our whistleblowing cases. This is not applicable to false claims that you would submit to a governmental agency, for example, under the Federal False Claims Act or your State False Claims Act. But assuming you're visiting our website today and interested in how you, as an individual employee, can protect your rights as a whistleblower, then this will be a very valuable bit of information that we'd like to share with you. Basically, all laws require that you have a good faith belief in an illegal act having taken place. An example has been given of a welder who believes that a bridge that he or she constructed was not done according to proper engineering standards and the bridge posed a safety hazard. They may or may not be right, but clearly, since they worked on the project or they talked to someone who did, they would have first-hand knowledge that this might possibly be an unsafe bridge with the danger of the public, so on and so forth involved. So they have a right to complain and be protected against retaliation as long as a reasonable person would believe that this was a credible concern. They do not have to be proven absolutely correct, just that there was a reasonable basis to believe that those welds in that particular bridge case are not safe. Secondly, as a whistleblower, you do have to be identified by name, and that means that, unfortunately, hard choices have to be made about protecting your privacy or not going forward with a whistleblower claim. Because if the employer doesn't know who blew the whistle, how can they retaliate against that person? Thirdly, we want to find out what is the act of retaliation that you have suffered. And the acts of retaliation for filing these complaints, which might have embarrassed the company, caused them inspection and re-engineering fees, bad publicity, things of that nature. What did they do? Did they demote you? Did they give you a false reduction in force notice of layoff? Did they send you to a very distant location where it was hard to get to work every day and they knew you would quit? Or they did not reimburse you the expenses for going there? Did they deny you training or a promotion that you believe you otherwise would have gotten? All of those are forms of retaliation. So these are the critical elements in most employment whistleblower claims: having something reasonably believed to be illegal, having spoken up on behalf of that issue so that it's known that you're the whistleblower, hopefully putting that in writing so that there's no doubt you were the whistleblower, and being retaliated against with some serious, significant adverse job action. So that's a brief overview of whistleblower retaliation. Again, to end where we began, if you're considering filing a false claim case with a governmental agency, whether your state, California, New York, Florida, whatever, or more likely under the Federal False Claims Act, then these rules do not apply, and we'll be covering that in a different video. Thank you so much.